Hey, Alysa, how are you?
Hello, good to see you.
Good to see you too. Hey, we're both West Coast, this week.
I know, feels good.
Just for
Although
yeah, I know.
it's kind of gloomy where I am. I don't know about you.
Okay. Well, it's nice and chilly where I am. So,
That is,
I want to talk to you about privacy policies. I don't know, sometimes they're an afterthought, but actually they're not an afterthought. The context I wanted to ask you about was with this steady drumbeat of new states coming along with their privacy laws and like the notices that are required for each one. How do businesses go about updating their privacy policies? I remember we were at, I think it was an IAB thing, and Michelle Lucan, the data privacy chief from Connecticut, was there. And she said, our law has passed and I'm looking at the privacy policies and they still say 2017. So I know you haven't thought about this, or at least you're not telling me you have. So I imagine each state is thinking about this and looking at this. How do you stay up to date?
well, it's number one, like it's the most visible indication of where you are on your state law compliance. And I think I'd put it into two buckets. I think a lot of companies were in a cadence of maybe updating their privacy policy once a year. And that was, it's a lot of work. You have to meet with a lot of stakeholders and you have to factually verify the facts that particularly if you're going to make updates, but also just to confirm that what you have in the privacy policy remains accurate. But now we have that extra complication of not just a few state laws, but you have more and more and more state laws coming online. And then thinking about, do I have to, yes, that state law is not coming online till maybe early next year, but do I take this state by state approach that I started with California and Colorado, or do I start making a state agnostic approach wherever I can to harmonize? And I think the numbers are kind of tilting. So that's one bucket, like companies really grappling with a faster cadence, and do they now make the state part more generic as opposed to specific to some states? We'll get back to that. And then you have the other bucket, I would say, who haven't thought about their privacy policy since 2017. They not big enough to have a privacy in-house counsel, maybe have resources that are a bit constrained to even use outside counsel. And so not really even, I think, as sensitive to how much more regulated the privacy space is. And so we're hearing from both, quite honestly, and really grappling with effective and practical ways to address that.
I mean, we talk about how they need to be easy to understand. And so I was doing some research the other day just to see, look for volumes on opt-out notices in California and deletions. And you get to these privacy policies of some big media companies, for example, and it's just state after state. And you're scrolling for a long time through this privacy policy. So you get to a point where you're like, okay, who is this for exactly? Is this for privacy policies for regulators or are they for consumers? Are they like how do you rationalize those two things? How do you do that? Like do you write for a regulator and legalese or do you write for a consumer to understand?
Well, I would say historically, they were an accountability measure. You had to state, you had to disclose certain things, and you were accountable to what you stated, because if you made misrepresentations in your privacy policy, that could be enforced. But I think with much more of a public spotlight on a company's privacy practices where non-lawyers, right, consumers are talking about privacy practices of particular companies, media is covering privacy practices of particular companies. I think when we do the updates to those policies, we have to be so much more sensitive that there is a range of audiences who are going to be reading it. And you have to balance, some of these states say you have to say things in a very specific way, which I would say maybe the layman is not going to understand. It sounds very legal. And then you have this other side where you need to make it make sense. And also you've got all these other stakeholders in your business that they look to the privacy policy sometimes for accountability, right? Oh, do we already disclose this in our privacy policy? Okay, it's included. So it's got to be usable and digestible for a range of different audiences.
So what do you recommend then on the state by state listing each one or kind of making it fairly generic in the state
Yeah.
section?
So one, I think companies are coming from a few different places. you have some where in order to really update the privacy policy, like take a whole new approach as opposed to just adding another state, they may need a lot more stakeholders, right? To vet the overall language and bless it and make sure it's accurate. And then you have others who, like if you're a newer company or you don't have as many decision makers, I think it's a lot easier. And I think those tend to lean on the side of, let's make it state agnostic so we don't have these particular state sections. So I think there's some operational concerns and constraints, depending on where you're coming from. I do think the scale is tipping though, and at some point, very soon, I think you're just going to continue to see more and more companies move to not a state-by-state approach and something a little bit broader.
Oh, sure. And it just gets ridiculous when there's 13, 15 of them, and each one that adds, yeah, I got you. Okay. Thanks. Thing I want to talk to you about is, are we having some conversations lately with companies who I guess are in the middle of brands and activating data on in ad tech. And so I was curious, like when you think about it in the context of an opt-out or a deletion, we've covered the B2C aspect of that, right? And but I wanted to ask you about the B2B aspect of that. So what are the obligations when it comes to deletion or opt-out for somebody who, for example, is activating data in ad tech, but through an onboarder or something like that?
Right.
What is it that you think about? Yeah.
Yeah, so we're talking about intermediaries, right, who don't have a direct relationship with the consumer, but are helping power different digital advertising or measurement or other use cases. And on the one hand, I think they often will take the position that they are embracing data minimization and that they don't want to have more personal information, right? They just have an ID or they have some limited data points. And the law is very specific to if they're a third party, right? They have obligations on what happens when they receive and what happens when they send on, but not necessarily working with partners to find a solution for how to persist and match for all of the privacy law compliance purposes. And it'll be interesting. I think for now, what the law ultimately says is if you have to have some contract terms that have diligence and you have to be reasonable. But there's not that much more in terms of what you need to do. A brand, for example, like may not be able to persist and opt out if it doesn't have additional matching information. And yet they may not be able to do anything about it without a B2B partner agreeing to help support some of that. And we have the processor needs to support, and that's built in under California law, for example. But I think the full context of what a third party needs to do, that's open-ended. I mean, we'll learn more from the Delete Act in California and how the regulations under that, what they spell out is required. I think that's an area where self-regulation has really been a vital part to fill in that gap. So TBD.
Gotcha. Okay. I didn't know there was another gray area. Alysa, I appreciate it. Thanks a lot.
Good to see you.
Good to see you too. Bye.